The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is Muha versus Wagner, and we will hear from the appellant.
Thank you, Mr. Chief Justice, and I would like to reserve 5 minutes of time for rebuttal. Good afternoon, Your Honors, and may it please the court. I'm Robert Parrott, and I appear today on behalf of Logan Wagner, the defendant in this case. Due process requires that in order for a state to assert personal jurisdiction over a non-resident defendant, the defendant must purposefully direct his conduct at that state such that he has a reasonable anticipation of being hailed into court there. This purposeful availment requirement is about treating defendants fairly and enabling them to structure their conduct in a way that lessens or avoids their exposure to a given state's courts. It provides potential defendants fair warning, which just a month ago in Ford Motor Company v. Montana 8th, the U.S. Supreme Court defined as knowledge that a particular activity may subject him to the jurisdiction of a particular state's courts. Here, Wagner has no connection whatsoever to North Carolina. There's no dispute that he didn't know Muha was in North Carolina when he called her. In fact, he affirmatively believed she was in South Carolina at the time. Wagner called Muha the day she arrived in North Carolina, and she filed suit against him less than 24 hours later. The first judge who heard her case found that no domestic violence had occurred. However, the Court of Appeals ruled that because Wagner purposefully directed his calls at Muha and to Muha's cell phone, and because calls to a cell phone can be received anywhere, Wagner had fair warning that he could be sued anywhere, including North Carolina. That holding confuses conduct that's directed at a resident of the forum with conduct that's directed at the forum itself. It also undermines the defendant's ability to structure his conduct in a way that lessens or avoids his exposure to a given state's courts. The Court of Appeals holding, in essence, is that anyone who calls a cell phone has constructive knowledge that their phone calls might subject them to suit anywhere. Muha argues that this court should affirm or go even further by reducing purposeful availment requirement to a negligent availment requirement or a strict liability standard. But the Court of Appeals holding is already a drastic expansion of personal jurisdiction doctrine. We've already seen it cited in a personal injury case for the proposition that the state's interests can predominate over the defendant's in a personal jurisdiction analysis. But I think that the potential for the Court of Appeals holding to be misused is actually most dangerous within the context of domestic violence proceedings, because it has the potential to place victims of domestic violence in grave danger. And to illustrate why I believe that, consider that anyone can file a domestic violence complaint against anyone else. And it's well documented, and anyone who practices regularly in domestic violence court will tell you that domestic violence complaints go both ways. Abusers will often file complaints against their victims, alleging that the victims are in fact the abusers. And that would, in those circumstances, the abuser would be able to reach out beyond the borders of North Carolina and physically pull the victim back into North Carolina. This type of abuse is called paper abuse. And it's just one way that abusers manipulate their victims. The Court of Appeals holding would force a non-resident victim who's been sued on an allegation that they have committed domestic violence against their abuser to choose between physically returning to North Carolina to appear in our courts in the same courtroom as the abuser, or to face the consequences of a potential, effectively a default judgment. And those consequences are serious. Entering a domestic violence protective order against someone exposes them to the threat of criminal prosecution. It puts the person's name in a national database of domestic abusers, and that entry is not subject to expungement ever. It can cause the person to lose a job or miss out on a job they would have otherwise gotten. It can cause them to lose housing. It can even be used as a basis for them to lose custody of their children. Every court that's addressed this issue agrees that a domestic violence protective order cannot impose affirmative obligations on a defendant absent personal jurisdiction. But the Supreme Court of New Jersey, as the Supreme Court of New Jersey recognized in Shaw, final domestic violence protective orders, like the one at issue here, inherently impose affirmative obligations on the defendant. For example, they require him or her to relinquish any firearms that are in his or her possession. That's an affirmative obligation. If the plaintiff comes within a certain distance of him or her, it requires him or her to get up and move. That's another affirmative obligation. If the plaintiff initiates contact with him or her, it requires them to initiate the termination of that conversation. All these are affirmative obligations that any final DVPO imposes on the person that it's entered against.
Aren't the concerns that you're mentioning now inherent in virtually every DVPO circumstance, irrespective of whether or not such would be the situation in a case like the present one?
Some of them are, such as a requirement to initiate the termination of plaintiff-initiated contact. That's inherent in every DVPO proceeding, even an ex parte one. Others are not. For instance, the requirement to relinquish firearms doesn't apply to ex parte DVPOs. And the entry in a national database is also a collateral consequence. It doesn't apply for ex parte DVPOs.
Well, why would those circumstances, the ones that you've just acknowledged as being perhaps specific and the ones that I'm talking about that are somewhat inherent in general, be germane to how this court would handle this particular case, wherein the Court of Appeals has attempted at least to say, in its opinion, would be decided based upon the relatively peculiar facts of this situation?
I'm sorry, Justice Morgan, I'm not sure that I understand the question. Could you repeat that?
Yes, I'll frame it another way perhaps as well. The majority decision in the Court of Appeals says that on the unique or peculiar or specific facts of this case, that it is holding as it does. You seem to be broadening it out in terms of talking about how it would affect DVPO matters. Why should this court, in light of how the Court of Appeals is framing its opinion, look at this wider aspect that you would like us to focus on?
Because I don't think that the particular circumstances that the Court of Appeals referenced, like the fact that she was a college student, really impose any significant, any meaningful limitations that would distinguish the facts of this case from any other case. I think that this could be, and we've been saying from the outset that this holding could be applied outside the domestic violence context. And in fact, just 2 weeks after this court took it up, we saw someone in a personal injury case cite this case for the proposition that state's interest could predominate over the defendant.
Well, in this mobile society we have these days, and I did not know until this case arose that our legal community is apparently celebrating the diamond anniversary of International Shoe, 1945 case. But be that as it may, are you saying that International Shoe should still prevail even in this age of the ongoing mobility of our society, with communication being anywhere and everywhere, globally even? Or are you suggesting that something different be done?
I do think that International Shoe should continue to be the foundation of our personal jurisdiction jurisprudence. And there's a great quote from Chief Justice Warren. I believe that was in Hansen v. Dekla, in which he noted the fact that as technology has progressed, residents from different states have come into contact with each other more frequently, and that's increased the need for not to assert jurisdiction over non-residents. And at the same time, technology has improved our communications ability, which has lessened the burden on non-residents of litigating in a forum form. But he pointed out that it would be a mistake, even recognizing those trends, it would be a mistake to assume that those trends herald the eventual demise of of International Shoe. And that's because the states Personal jurisdiction is more than just a guarantee against inconvenient litigation. It's also a function of the state's status as a co-equal sovereign in a federal system. And so those limitations will persist despite the progress of technology.
Well, in light of the technology advancement as it is, and I know that phrase being held into court is some case law terminology, why would your client not be in position to understand that if the other party was a college student who had just finished her college career, was based in another part of the country in terms of her hometown area, was attending school in South Carolina, that when he called her 28 times, she could have been anywhere? Why would that not be impugned to him to be a circumstance where he doesn't know where she is, and as a result, if there's some legal action, he's taking a chance?
I think that this would be a different case if he knew, for instance, that she was traveling. You know, if he knew that she was on a road trip across the country and he just didn't know where, then this might be a different case, but that's not the situation here. He affirmatively believed that she was in South Carolina. He called a South Carolina phone number. She hadn't told him that she would be traveling. I don't think that the fact that she's a college student makes it any more likely that she would be in many different places, as the Court of Appeals said, than anyone else who has a cell phone or a car or legs. I think that, and I also would point out that she was in fact finishing up her first year in college. So she had moved here just for the summertime. But I don't think that the fact that she was a college student imposes any meaningful basis to distinguish the facts of this case from any other one. Does that answer your question?
It does. Thank you.
Thank you. So Muha proposes that this court adopt a status exception to the personal jurisdiction requirement. And that too is dangerous for just the same reasons that I mentioned earlier. It would allow anyone who files a complaint alleging that someone else has committed domestic violence against them to reach out beyond the borders of this state and require that person to appear physically in North Carolina. And most states would allow a victim of domestic violence to testify remotely, or a defendant who's been hailed into that court's jurisdiction to testify remotely. North Carolina is not one of those. We have a statute which specifically requires that the defendant and the plaintiff appear physically in the same courtroom at the same time and testify. And that, especially for a state that has that requirement, such as ours, adopting a blanket status jurisdiction rule would allow anyone to file a complaint, even abusers themselves, alleging that a victim had committed domestic violence against them, and then would require the victim to show up in North Carolina or face the drastic consequences of entry of a DVPO by default. And for those reasons, and I also will note that that Muha has proposed a middle ground here. She's also proposed a negligent availment standard. In other words, she's proposed that an abuser should be required to ask his or her victim, when they call the victim on a cell phone and speak to that victim, the abuser should be required to ask the victim where he or she is, and the victim should be required to tell him. And I think that is obviously a bad public policy. Victims should not be required to tell their abusers where they are. And in fact, by filing in North Carolina, Muha told Wagner where she was. I think that's not a good outcome. It's also worth noting that VAWA, the Federal Violence Against Women Act, would only require other states to enforce a DVPO if if the rendering state had personal jurisdiction. And so I think that if we were to eliminate the personal jurisdiction requirement altogether, it would not only reveal the locations of, reveal where the person is fled to, but it would also undermine the effectiveness of the order itself. And it's worth noting that the facts, as Justice Morgan pointed out, the facts of this case are somewhat unique, although not necessarily in the way that the Court of Appeals pointed out. You know, in most cases involving interstate flight from domestic violence, the victim is going to flee to a place where she has family or some sort of community support. And in most cases, the abuser is going to know where she has family. And in those cases, that would provide a basis to say, you should have known that that's where she was going to flee. But this case is unique because Muha went to a place where she didn't have any connections. And in fact, she didn't come to North Carolina fleeing from Wagner. She came to North Carolina for her summer break. I think that.
Well, can I, looking at the potential broader consequences of the decision in this case for doctrines of personal jurisdiction, isn't it true that the Supreme Court in interpreting due process there's the minimum context fundamental notion, but there's also a notion that it's the conduct of the defendant that needs to be examined in order to establish jurisdiction. And so it's the defendant that has to have some kind of contact or connection with the jurisdiction in order to justify under due process the ability to have a court to have jurisdiction over them?
Yes. And I think, Your Honor, that the Supreme Court has said that the connections can't be merely fortuitous. And I think that that's precisely the principle that the Court of Appeals holding here violates. Because what they've said is when you call a cell phone, you create connections with wherever the recipient of the cell phone call happens to be received. And so you haven't purposefully developed connections with that state. Your connections to that state are merely a function of wherever the owner of the cell phone happens to be. And I think that sort of goes to the heart of the issue here. I also think, Muha has pointed to the Burger King factors. And I would submit to the court that those are a secondary analysis, but that the purposeful availment requirement is a threshold requirement. So for instance, in a business litigation case, those Burger King factors might mean that 15 emails and 40 phone calls are not enough for personal jurisdiction in that context. But in a context like this, 5 phone calls might be enough. But in every case, there has to be some act by which the defendant purposefully avails himself or purposefully directs his conduct at that state itself, such that he had reasonable anticipation that that state's laws might apply and that he might have to litigate there. And, for those reasons, I think that this court should adhere to, because of the severe collateral consequences that defendants can suffer as a result of a default judgment, and because of the danger that this would place victims of domestic violence and who have fled from North Carolina to other states, I think that this court should adhere to standard jurisdictional rules. And in like I said, in most cases involving interstate flight from domestic violence, the abuser is going to know or have some, or should know that the place that the victim has fled to would be where she would flee to, because it's going to be a place where she has family or something like that. In this case, Muha had no connections like that to North Carolina, and Wagner had no connection to North Carolina. I would submit to you that calling a cell phone with a South Carolina area code doesn't amount to conduct that's purposefully directed at any place where those cell phone calls happen to be received. And this court should, for those reasons, reverse the trial court's assertion of personal jurisdiction over Wagner. And unless the court has any further questions, I think I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court. I'm Eric Zimmerman with Robinson Bradshaw, representing the appellee, Marissa Muha. Mr. Wagner committed domestic violence against a North Carolina resident, Ms. Muha, while she was in North Carolina. He did so by calling her cell phone 28 times in a single evening. Mr. Wagner knew that Ms. Muha suffered from panic attacks, and his 28 calls here triggered a panic attack. His calls left Ms. Muha locked in the bathroom, curled up in a ball in the shower, crying, shaking, and having difficulty breathing. All of those effects occurred in North Carolina. Even though he harassed and injured Ms. Muha in North Carolina, Mr. Wagner argues that he can't be sued in North Carolina. He says that he didn't know that Ms. Muha was here when he committed domestic violence against her. And he says that his mistake about where she was, and his mistake thinking that she was in South Carolina, is a defense against personal jurisdiction and means he can't be sued in Ms. Muha's home state of North Carolina. Mr. Wagner's argument is wrong. As the Court of Appeals held, in the particular circumstances of this case, and Justice Morgan, you're exactly right, the Court of Appeals ruling was focused on the particular circumstances of this case. The Court of Appeals held that Mr. Wagner had fair warning that by committing domestic violence against Ms. Muha, he was subjecting himself to suit in North Carolina. And the reason for that is
Mr. Zimmerman, there's been lots of discussion in the briefs about whether the Court of Appeals decision is limited or opens the floodgates. What is your understanding of what the set of circumstances that the Court of Appeals decision is limited to?
I believe it's limited in a number of key ways, Your Honor, and here are a few. So number one, it's limited to the domestic violence context. And the Court of Appeals was careful to say on page 448 of its opinion that its decision was based on the nature and context of the conduct here, which was domestic violence, and that it's based on the state of North Carolina's strong interest in preventing this kind of harmful personal interaction. That's how the Court of Appeals put it. And so that's a limitation to the domestic violence context. The other key limitations are, as I said at the outset, that Ms. Muha is a North Carolina resident, and the domestic violence occurred while she was in North Carolina. So in fact, when you look at it, the domestic violence actually occurred here in North Carolina. That's where the last element of the domestic violence happened. That's where she received the calls and suffered the domestic violence. So she suffered the domestic violence here, and she's a resident. So what we're saying is that when you take those factors together, and when you look at the Burger King decision from the US Supreme Court, which sets up a sliding scale analysis for the minimum contacts that are required to satisfy due process, that we have those factors, domestic violence, North Carolina resident, domestic violence happens in North Carolina, the necessary showing of knowledge that's needed to satisfy minimum contacts is particularly low. And I think a good way to look at that is that what Burger King says is that to establish minimum contacts with the forum state, the defendant needs to create a substantial connection to the forum. And I think you can look at the substantial connection requirement as having two ingredients. It involves the defendant's conduct. And Justice Earls, we totally agree. You have to look at the defendant's conduct. And that's what we're looking at here. The defendant here reached out into North Carolina with his phone calls and made contact with North Carolina. So that was his conduct. Mr. Wagner's conduct is what made the connection with North Carolina. But
if I'm understanding Mr. Parrott's argument, and he's got a fair amount of time in rebuttal to correct me if I'm mistaken, he's in essence saying that we don't even get to these 5 factors because there is no purposeful direction of activity to North Carolina, given that Mr. Wagner didn't know where Ms. Muha was. Is the purposeful direction a prerequisite regardless of the effect of the Burger King factors to exercise of jurisdiction in this kind of case?
I agree purposeful direction is needed, Your Honor, but there's a question of how much purpose is needed. And the factors from Burger King on fair play and substantial justice are what weigh in that balance and tell you how much purpose is needed to give rise to minimum contacts.
I mean, if
My friend,
I understand his argument, he's disagreeing with you on that point and saying in effect that there is a minimum level of purposeful direction that has to occur, and that the extent to which such a minimum amount of direction happens is unrelated to the Burger King factors. You obviously disagree with that. Tell me why.
well, I disagree because that argument from my friend just doesn't make sense of the language on page 477 of the Burger King opinion, which describes the fair play and substantial justice factors. And then it says that in some cases, those factors, and I might as well quote the language because it's important. It says that those factors sometimes serve to establish the reasonableness of jurisdiction upon a lesser showing of minimum contacts than would otherwise be needed. So what that language is saying is that in some cases, when the fair play and substantial justice factors are compelling, then there's a lesser showing of minimum contacts that's needed. My friend says you need the same showing of minimum contacts in every case. And I just don't see how that can possibly be squared with the language in Burger King saying you need a lesser showing, depending on what the factors are.
Well, how do we read that then in conjunction with a more recent U.S. Supreme Court decision in Walden versus Fiore, and language there that seems directly applicable here? And I think Walden was a tort case, and not a business case. And in Walden, the Supreme Court said due process requires that a defendant be hailed into court in a forum state based on his own affiliation with the state, not based on the random, fortuitous, or attenuated contacts he makes by interacting with other persons affiliated with the state. And what seems particularly challenging in Walden is that there the plaintiffs knew that Nevada, or they knew where the person was when they engaged in the allegedly tortious conduct. It wasn't a situation where here if we were to adopt this rule, a defendant would be subject to jurisdiction anywhere in the country without them knowing. Whereas in Walden, even before filing suit, the plaintiff knew where the defendant was, but the Supreme Court still said that was not enough of a connection to justify under due process establishing jurisdiction. So how do we square this with Walden?
The way to square it, Your Honor, is that the problem in Walden was that the defendant in Walden confined all of his conduct within his home state of Georgia. And the Supreme Court emphasized several times that the defendant did not make any contact with Nevada. He never sent anything to Nevada. He never called anyone in Nevada. He never contacted anyone in Nevada. And so the problem in Walden, you're exactly right that he had knowledge, but the problem was he didn't actually make any contact with Nevada. And so the reason that this case is different is because Mr. Wagner made contact with North Carolina. He made 28 contacts with North Carolina. He called Ms. Muha's cell phone in North Carolina 28 times. And so this is not like Walden, in which the defendant, confined his conduct entirely within his home state. Here, Mr. Wagner made a connection with North Carolina by calling Ms. Muha here. Now, my friend on the other side says that wasn't a contact with North Carolina because he was just calling Ms. Muha. He wasn't calling North Carolina. But that's wrong. And what Walden recognizes is that the contacts with the plaintiff and the contacts with the forum can be intertwined. It uses that word, intertwined. And that's exactly what we have here. Mr. Wagner's contacts with Ms. Muha and North Carolina are intertwined because he made the contact with North Carolina while she was here. This would be a very different case if Mr. Wagner had called Ms. Muha 28 times while she was in South Carolina, and she had then moved to North Carolina and suffered emotional distress here. That is the kind of situation that Walden was concerned about, where the defendant engages in their conduct that conduct is directed at one state or makes a connection with one state. And then after the defendant has engaged in his conduct, the plaintiff then moves around and the defendant loses total control of where his conduct might subject him to suit. So we agree this would be a very different case if the timing were reversed and the calls had happened in South Carolina, because then in that case, the defendant himself wouldn't have made a connection with North Carolina. But what happened here is that the defendant made a connection with North Carolina. He called into the state. And so that's why what we're arguing here is consistent with Walden. Now, Justice Early, as you noted, there was no knowledge question in Walden. So the US Supreme Court didn't speak to the issue of what knowledge is required in Walden. And frankly, we don't think that the US Supreme Court has ever directly spoken to the level of this kind of knowledge question where you have a defendant saying he made a mistake. I think the closest case that deals with this sort of mistake argument is Burger King itself, where in that case you had the defendant, the local franchisee of Burger King, who was in Michigan, and Burger King sued him in Florida. And the defendant in Michigan said, I thought I was just dealing with the local Burger King office here in Michigan. I didn't ever expect that Burger King would drag me into court in Florida. And what the US Supreme Court said was, no, you should have known based on the contract that you entered into with Burger King that you could be sued in Florida. And if you look at footnote 24 of Burger King, it's all about what the defendant in that case should have known, what the contract should have suggested to him. And so Burger King, I think it's the closest case, and it deals with this kind of mistake argument that Mr. Wagner is making in exactly the way that we suggest is right, which is that you should look at a should have known standard. And it's an objective standard that looks at what the defendant had reason to know. And by the way, my friend on the other side just agreed with that today in his argument when he said, if he had reason to know that Ms. Muha was traveling across the country, he could be sued anywhere based on calling her cell phone. And so I think he's admitting that it's a should have known standard, and he can be sued where he has reason to know she could be.
What is your response? What is your response to opposing counsel's position that the traditional notion of due process, which is encompassed in international shoe, should be applied here?
I agree that the same standards from international shoe apply here, but it's a question of taking them and applying them to the particular facts of this case. And Justice Morgan, I think you're exactly right that we need to think about the technology that's going on here. And I think it's a really key point that what we're dealing with here is a cell phone. And here's why I think that's so important, particularly in a domestic violence case. Because in a domestic violence case, where the defendant is trying to harass the victim, calling a cell phone is a particularly powerful tool that the defendant can use in a domestic violence case to harass the victim, because it allows the defendant to reach the victim wherever she is immediately and harass her wherever she goes. So it's a very powerful tool in the hands of an abuser. And what we're saying is that if the defendant chooses to make use of that powerful tool of a cell phone, then he needs to take the bitter with the sweet. And he needs to recognize that when he calls that cell phone, it could be anywhere. And he could be subjecting himself to suit wherever the cell phone is, or at least wherever the victim lives and receives those calls.
How do you square go ahead.
I think it's just a quick question. I think you're obviously correct that the cell phone is a powerful tool and could change things, particularly in the context of domestic violence. But it seems to me that Burger King and Walden and other cases draw a clear distinction between contact with a resident and contact with the forum, and say that contact with the resident alone is not enough to establish the minimum contact from which you then can apply the other factors in Burger King. And so I'm wondering if you would agree that this would be a departure from those precedents, and whether you think that that's a step that we should be taking.
No, Your Honor, I don't agree that it's a departure from those precedents, because here Mr. Wagner made contact with North Carolina. He called into North Carolina. And so it's different from Walden, where the officer never called into Nevada. It's different.
Well, he was calling the resident. That's the distinction that's drawn in the cases.
Well,
wasn't he?
So he was calling the resident, and she was in North Carolina. So what I'm saying is there would be a distinction if he called a North Carolina resident while she was not in North Carolina. So if Ms. Muha was a North Carolina resident, but she was off in California for the weekend, and he called her in California, he wouldn't have been contacting North Carolina. So what's key here is that you have the combination of the North Carolina resident and the calls coming into North Carolina. So that's the contact with North Carolina. My friend is trying to say that because he didn't know she was here, that means it wasn't a contact with North Carolina. But I just don't think that analysis works. Whether or not he knew she was here, his phone calls came directly into North Carolina. And so he was making a contact with North Carolina.
So just to follow up quickly, I think, I know that there are states that have found a status exception, but is there any state that has ruled that you can extend personal jurisdiction based on a cell phone call when the caller has no knowledge of where the recipient was at the time they made the call? Because I mean, cell phones are not that new. We've had them for a while.
No, Your Honor. So, I mean, we acknowledge that there is no case holding that there are minimum contacts in a case like ours. There also is no case going the other way. And so I agree, cell phones are not new, but, they're relatively new. And I think that helps to explain why this sort of case has not come up before. My friend on the other side points to the Becker case from Florida, but that case just turned on a procedural problem, which was that the plaintiff in that case had not put in an affidavit showing the evidence of what the defendant knew. And so there's no case out there that squarely addressed this problem of what the level of knowledge should be in this situation. And so, we think what the court needs to do is go back to first principles. And the first principles here are that you're looking at fair warning and where the defendant can reasonably anticipate being sued. And we think that the Court of Appeals got it right when you're dealing with a domestic violence case, which is such serious and dangerous conduct, that the level of knowledge that's needed for that conduct to create a substantial connection with the forum is particularly low.
How do you square the embrace that you have of International Shoe, which you identified with me a bit ago, with the Court of Appeals recognition that when, and I'm quoting from the Court of Appeals decision, that when he called her on her cell phone, she could be in many different possible locations, unquote, talking about the defendant here calling the plaintiff. In International Shoe, the forum state, as I recall it from eons ago when I was in law school, was fairly established among the parties. But here, North Carolina being the forum was not as established, to put it mildly. So how would you square your embrace of International Shoe with the Court of Appeals determination that the plaintiff here could have been in many different locations?
Well, Your Honor, what I'd say is yes, in International Shoe, the defendant knew about the forum. In every other case, I totally agree. In every other case where the U.S. Supreme Court has held that there is jurisdiction and that due process was satisfied, that there was some knowledge, or at least we're dealing with minimum contacts here, so I want to put the status exception aside, but on minimum contacts, I agree that there was at least reason to know where the defendant is. But what we're saying is there's reason to know here as well. And what we're just saying is that the amount of knowledge you need to provide the relevant reason to know varies based on the circumstances. And at least when you're dealing with a domestic violence case, because the fair play and substantial justice factors so strongly favor allowing the victim to bring suit in her home forum, the amount of knowledge you need to provide the reason to know and to provide the fair warning that the Supreme Court's cases say is needed is particularly low. And so when you have a defendant who calls a cell phone to commit domestic violence, and he knows that the victim is out there somewhere, but he just doesn't know where, then what we're saying is that's enough knowledge because the conduct is so serious and dangerous, because the state has such a strong interest in providing a forum in which its residents can seek protection from that kind of dangerous conduct. The level of knowledge is lower. And so, the US Supreme Court has never had a domestic violence case. And so it's never addressed these particular circumstances. And this is a highly circumstance and fact dependent area of the law where it's hard to draw bright line rules. And we think that what the Court of Appeals did here was to correctly look at all the circumstances of this case and hold that here there was enough knowledge given the domestic violence context to allow personal jurisdiction and hold that there were minimum contacts.
Am I hearing threaded throughout your position that should this court decide that your argument is persuasive, that the opinion should be limited to the domestic violence area?
Yes, Your Honor, we would be perfectly satisfied with that. That's how we read the Court of Appeals opinion, and that's all the court needs to address in this case is the domestic violence context, and even more particularly, the domestic violence context combined with the facts of this case. And when you look at all the circumstances of this case, they're enough to provide minimum contacts. And I want to emphasize the flip side of this, which is Mr. Wagner's approach, which would be dangerous. Mr. Wagner's approach is that domestic violence victims in Ms. Muha's position can't seek relief in their home states and instead need to seek relief in the home states of their abusers. But requiring a domestic violence victim to go to her abuser to seek protection is just requiring her to put herself in harm's way and expose herself to more violence. So it really turns the whole point of the domestic violence proceeding on its head. Now, my friend, for the first time in his reply brief, argues that if Ms. Muha had brought this case in Connecticut, she could have done it remotely, and she could have filed the case by email and participated by video. But he's just wrong about those things, and we submitted additional authorities to show that he's wrong. Filing by email was a measure that the Connecticut courts put in place in 2020 to deal with the COVID-19 pandemic. And you can see that just from looking at the authorities my friend himself cites in footnote 8 of his reply brief. So Ms. Muha wouldn't have had access to remote filing when she filed this case in 2018. My friend also...
I'm sorry to interrupt, but I do want to just be clear about your contention on how we can somehow limit the finding that there is personal jurisdiction here to the domestic violence context. And I guess I understand you to be saying that the due process clause might in fact have a domestic violence exception, and the Supreme Court just hasn't dealt with domestic violence cases yet. Or I guess, where do we find the domestic violence exception to due process?
I don't think it's an exception to due process, Your Honor. What I'm saying is that if you look at Burger King, it's established a sliding scale for how much is required in terms of minimum contacts. So you have the minimum contacts analysis, and you have the fair play and substantial justice factors, like the state's interest in providing a forum, the plaintiff's interest in convenient and effective relief, the burden on the defendant, the shared interests of the states, and the interests of the interstate judicial system.
And I'm sorry, let me ask you about one other factor then. You said earlier the fact that she's a North Carolina resident, and I guess on the facts of this case, at the time she filed this, she had been in the state maybe 24 hours. If she had move, if she had then gone to Tennessee the next day, or I mean, I guess, is being in the state one day enough to be a North Carolina resident to file a lawsuit in these circumstances?
We believe it is, Your Honor. We don't believe that there should be any kind of waiting period before someone should be considered a North Carolina resident. And it's especially important not to impose that kind of waiting period in the domestic violence context where victims need protection immediately. And it would be dangerous to require them to wait and say they're not yet residents and not allow them to sue. Now, my friend.
No, so I'm with you there, but then how does that limit this in any way? Because it seems that, people could travel to any state and that day take advantage of the state's jurisdiction. So how does the fact that she's a resident really limit the application of this doctrine? Like, in other words, people could come to North Carolina, I guess is the best way to say it. People could come to North Carolina and that day file their lawsuit.
Well, I think they actually need to become residents, and residency means you are planning to stay here indefinitely. So I don't think they could just come here, get a protective order, and then go back. I think they would need to become here and establish residency. I don't think it takes an amount of time to do that. As long as you move here with an intent to stay, you're a North Carolina resident. And so that is a limitation. My friend has said in his reply brief for the first time that Ms. Muha wasn't a bona fide resident of North Carolina because, according to him, she just moved here for the summer and then moved back to South Carolina. But there's absolutely no factual basis for that assertion in the record. The district court found that Ms. Muha was a North Carolina resident at the time. And there's nothing in the record to suggest that she ever moved back to South Carolina. So, she's a bona fide North Carolina resident. My friend has never challenged that before. And in fact, in the district court at the hearing, he told the district court, we're not here challenging that Ms. Muha is a North Carolina resident. That's at pages 16 to 17 of the trial transcript. And so, I think that as this case comes to the court, Ms. Muha is a North Carolina resident, and that's a limitation here. And especially when you combine that with the fact that she received the calls here. So we're not saying that if she got the calls in South Carolina and then moved here and became a resident, that would necessarily trigger minimum contacts. So it's really the whole combination of factors. But I also want to just briefly touch on, we've been focused on minimum contacts here so far. We also think that the status exception justifies jurisdiction in this case. This court just last year unanimously held that the status exception to minimum contacts applies in termination of parental rights cases, in the FSTY case. And we think that all the reasons the court gave for applying the status exception in termination of parental rights cases also apply in domestic violence cases. And in fact,
how do we have a status in this case that is equivalent to the parent-child relationship, the spousal relationship that you see in divorce cases, that seems to be the linchpin of status exception cases?
Well, Your Honor, here we have a domestic relationship. So we have the domestic relationship between the plaintiff and the defendant. And what the court is doing in a domestic violence protective order proceeding is addressing the status of that relationship by severing it. It's cutting off that relationship. And we think that is the same sort of thing that the court does in the termination of parental rights case, where you have a relationship between the parent and the child, and the court is severing that relationship. And so, we think it's status in that same way. Another way to look at it, there have been many courts that have applied, many state Supreme Courts that have held that the status exception applies to domestic violence cases. And they've said you can also look at it as like the court is addressing the protected status of the victim vis-a-vis the abuser. And so really the key rationale for the status exception is that the state has the power to protect its residents from harm from out-of-state abusers, and they don't have to wait for the abuser to come into the state and create contacts before doing that. So ultimately here, Mr. Wagner committed domestic violence against a North Carolina resident while she was in North Carolina. we think he created minimum context by doing that, but at the very least, the status exception should also justify jurisdiction here. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. So I have a number of points that I would like to bring up that my friend mentioned. First of them is I'd like to follow up on Justice Irvin's comment that we do indeed argue that we don't even reach the Burger King factors in this case because the purposeful availment requirement has to be met in every case. And I'd just like to point out that intent is intent regardless of the context. Based on Muha's logic, the state's burden of proving specific intent to kill in a murder case is lower than it is in the context of a prosecution for assault with intent to kill. But that's not the way that it works. Your constitutional protections are, if anything, greater the more serious the charges are. And to answer the question of how those Burger King factors tie in, my friend said that view that that purposeful availment is required in every case is difficult to square with the sliding scale that Burger King establishes. I would just like to reiterate that sliding scale relates to the number and quality of the contacts that are necessary to satisfy the reasonableness problem. So, in other words, in a business litigation context, 15 phone calls and 40 emails might not be enough, but in a domestic violence context, it might be. That's the sliding scale that Burger King is at. My friend also mentioned that Burger King, he believes, is the closest case to addressing the intent requirement for purposeful availment, but it's not. We agree that the Supreme Court has never directly addressed what purposeful means, but I would submit to you that the closest case here is Mcintyre Machinery versus Nicastro. Now, like Burger King, that was a business litigation case, but it addressed the facts here more squarely than Burger King does. In that case, a British machine manufacturer sold industrial manufacturing equipment to a U.S. distributor. They didn't know where their machines might be sold. They just knew they were going to be sold somewhere in the U.S. The New Jersey Supreme Court held that the fair warning requirement was satisfied because the manufacturer knew or should have known that its products could be sold in any of the states, including New Jersey. The U.S. Supreme Court reversed, recognizing that even though the manufacturer reached out beyond the borders of Great Britain, its mere knowledge that its products might be purchased in any of the 50 states didn't amount to conduct that was purposefully directed to New Jersey. That same logic applies here. The British manufacturer's placement of the machine into the U.S. stream of commerce is like Wagner's placement of a cell phone call into the cell phone network. Just like the machine, his cell phone calls could be received anywhere. They might land anywhere. And just as the manufacturer's placement of that machine into the stream of commerce wasn't conduct purposefully directed at New Jersey, Wagner's placement of a call into the cell phone network was not conduct that was purposefully directed at North Carolina. And it's also worth noting that there are no cases out there that have held that cell phone calls in a circumstance like this would be sufficient to establish purposeful availment. But I disagree with my friend's assertion that Becker v. Johnson is not on point. That Florida case is directly on point. In that case, the non-resident defendant called and texted the plaintiff repeatedly on her cell phone, threatening her, which is not a fact that we have here. The Florida Supreme Court's decision that there was no personal jurisdiction didn't turn on the fact, if you read the opinion, it didn't turn on the fact that there wasn't an affidavit entered in the case. It turned on the fact that the defendant didn't know and that there was no evidence that the defendant knew that the plaintiff was in Florida when he called and texted her. My friend also argued that the additional authorities that he filed established that Connecticut would not have allowed Muha to testify and file remotely. He argues that those measures that Wagner cited in his brief were measures that were adopted just to deal with COVID. But he's wrong about that. First, the additional authorities that he filed are orders that specifically authorize plaintiffs to file and testify remotely. But that's not the same, but the absence of an order that specifically authorizes that is not the same thing as an order or statute that specifically prohibits plaintiffs or defendants from testifying remotely, like North Carolina statute has. He hasn't pointed to any Connecticut order that says prior to COVID that plaintiffs and defendants couldn't testify remotely. And second, I think that his assumption that the court wouldn't have the inherent.
I don't want to get too far down in the weeds, but was there a prohibition in Connecticut against the use of remote testimony?
No.
Was there an express authorization?
No, there wasn't. But I'd like to show the court.
I mean, can you before you show what you're getting ready to show? I don't want to stop you from doing that. If something is not expressly authorized, what's your sense of how likely a trial judge is going to be to do it?
Well, I think that courts have the inherent authority to permit parties to testify remotely in the absence of such an order. And
go ahead and show your document now. I'm sorry to interrupt.
Oh, no problem at all. So I'm sharing my screen. Is everybody able to see this? It's a pamphlet that Connecticut provides for victims of domestic violence who want to file relief from abuse orders. Is everyone able to see this? Can folks see this?
Yeah. Yes.
Okay, thank you. So I just want to point out first that this is a document that we cited in the footnote that my friend referenced. It was revised in October of 2016, well before coronavirus hit. And it says on page 2, testimony by other means. Before the hearing, you may file a motion asking that your testimony be taken in a different place away from the respondent. The judge may order the use of video conferencing or another way for you to give testimony. So I think that undercuts the, Muha's assertion that that she would not have been able to testify remotely. If I can stop sharing. I'd also like to point out that I think that Muha's status as having just moved here. Well, actually, let me back up. With respect to the status that my friend pointed to, I think that logic, the relationship between the parties, would apply to virtually any proceeding. For instance, one business might say, well, the court should apply status exception jurisdiction to allow me to hail in this non-resident company that has no connections with North Carolina because we have a relationship, a contractual relationship. And I think that the facts of FSTY are very different from the facts here because first, that case turned on the best interests of the child, and we don't have any independent standard like that applies here. And also in FSTY, it was very important to the court that the defendant could have applied to testify remotely, and here that fact doesn't exist. We have a statute that specifically prohibits courts from allowing a non-resident defendant from testifying remotely. I think that this case is also, my friend pointed to the fact that Muha had just moved to North Carolina and our pointing out that she wasn't a bona fide North Carolina resident. I think that the facts presented here are very similar to the facts that the Delaware Court of Appeals addressed in TL versus WL. In that case, you had a plaintiff who fled to Delaware, filed suit 2 days after moving there. The Delaware court found that it didn't have personal jurisdiction over the non-resident defendant, and the plaintiff argued that it should adopt the status exception to issue a DVPO nonetheless. And after analyzing the status exception, the Delaware court decided that in cases that it had asserted the status exception before, like marriages, for instance. It only did so in cases where the plaintiff was a bona fide resident of Delaware. And in this case, it found that because the plaintiff had filed suit just 2 days after moving to Delaware, she wasn't a bona fide resident of the state. Well, here, Muha had been in North Carolina even less time than the plaintiff in TL versus WL. And for those reasons, I don't think that the court should apply the status exception. Certainly don't think it should apply the negligent availment standard that Muha proposes. And I don't think that it should find that conduct, that placing a call to a cell phone subjects you to jurisdiction anywhere that the calls might happen to be received. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.